The San Francisco Symphony brings extraordinary multi-sensory experiences to the immersive underground club atmosphere of Soundbox. February 6th and 7th, be surrounded by the dream world of Dream Awake, a new program curated by violinist Alexi Kenny. Experience the sounds of a lush garden at twilight, the fear and frenzy of a shadowy nightmare, and a finale warmed by the welcome rays of the rising sun. Don't miss Soundbox, February 6th and 7th. Tickets at sfsymphony.org.
Welcome back to Come Back with a Warrant podcast. I'm Brandon Dinitz.
And I'm Monica Ashak. Before we kickstart this week's episode, this is your reminder that this podcast is not legal advice. It's real, unfiltered, and for entertainment purposes only. If you need to speak with a lawyer, call one. Or better yet, call us. Okay, so today we will be talking about sentencing, and specifically Florida sentencing. I was going to say guidelines, but not just sentencing guidelines, because that does apply to felony cases. Just generally, what's the process of sentencing, how the process goes, what to expect, the different types of enhancements. And really, this is the only math that I think lawyers, I shouldn't say lawyers generally, criminal defense attorneys do, because we have to calculate our client's jail credit and calculate how much time is going towards that sentence that they're going to be receiving. And so there's so many different ways you can get to sentencing, and we'll talk about that. But there sounds like, I think when we were first talking about it, it felt like very like, oh, we'll talk about sentencing, but there's actually so much that goes into it.
Yeah, that's true. And you have, sentencing is so different from based on the severity of the charge. Mm-hmm. And when we're talking about sentencing, we're talking about what happens at the end of a criminal case.
Yes.
Okay. Not the end meaning an appeal. We're talking about the end of a criminal case where before that appellate process would start, we're talking about a case resolving either in terms of a plea or a trial and a conviction. So once somebody has either been found guilty or entered a plea of guilty, they are sentenced. And that sentence can come from a few different places. That sentence can come from the agreement between the parties, meaning the state attorney's office and the defense. That sentence can come from the statute, like in a DUI, where certain probation requirements are required if you're convicted of a DUI. Or that can come from the score sheet, if we're talking about felonies.
Yeah.
And that is your criminal history being given points and the current crimes you are charged with being given points. And those points are added up. And sometimes, and we'll discuss it, there are sentencing minimums where a judge would have to start a sentence at a minimum. But this episode is going to really almost answer the question of how can two people be charged with the same thing and be sentenced differently?
Yeah.
Okay.
To a certain extent.
To a certain extent, that'll answer it, because I'm sure there's a lot of answers you could give for that question. Yeah. But the truth, what this comes down to, what we're talking about is the process of sentencing as a whole.
Yeah. And so and specifically when I said sentencing guidelines, that's exactly what Brandon was describing in felony cases, where it's a score sheet that shows your rap sheet and it computes a number that says this is the minimum. And so that was created in an attempt to try to make it kind of so that people who have similar histories or are in similar situations in terms of what they were charged with, not fact specific, these are things that would guide the judges or the courts to give a certain sentence. And in the same sense where it's charges, there's, mitigation or downward departures in that situation. So there are so many ways that we can get there. And you said guilty plea, and I think that's because in Palm Beach County, we're so used to talking about guilty.
Could be a no contest
Could be a no contest plea as well. So no contest is just the same exact thing legally as a guilty plea. It gives you the same effect, but some people are just more comfortable saying that they plead no contest and they'll accept their sentence, and that's literally what it is. So
no contest is saying that you acknowledge that there is evidence and you could be found guilty. Not that you are saying you are guilty, but you could be found guilty and you're acknowledging that. That's really what no contest is.
No contest.
If they resolve it with no contest, then there is less ramifications in a civil case than if they were to be found guilty or they were to admit guilt themselves.
Right. Because then there's like points with your license or whatever. Yeah.
Right. They have a civil case going on because there was a car accident involved in whatever the criminal case was. Their attorneys often prefer if it's a no contest versus them just admitting and being found guilty. So for what it's worth, there is a difference there. But
well, strictly for criminal law.
For criminal law, there is really no difference
in Florida. So the easiest way to break this down generally is to know the difference between a misdemeanor and a felony. There's so many words we throw around that are so easy for us to talk about, and because we know it, but we need to break it down. So misdemeanor, and there's degrees and levels to each one, to both misdemeanors and felonies. And so misdemeanors, the highest degree is a first degree misdemeanor, and that's punishable by up to 1 year in the county jail and $1,000 fine. And when we say 1 year, that's 364 days, and that matters.
Right.
364 days in the county jail. And so when it comes to felonies, anything above 364, that's it, or punishable over 364 would be considered a felony. So a year plus.
And that's also where, at least in this state, we get the difference between jail and prison. Jail is usually run by the counties. Prison is run by the state. The jails, somebody is supposed to be sentenced up until a 364, so less than a year. Sometimes people spend more than a year in, but generally speaking, they're supposed to be under a year in a jail. And if their sentence is over a year, it is in prison. That is also that also translates to the misdemeanor and the felony. Generally speaking, a felony is punishable by over a year, where a misdemeanor is generally punishable by just under.
And the reason why, and sometimes people do end up serving their prison sentences in jail, and the reason why is because what happens is they're waiting in custody pre-trial. So that's where people are housed, is in the county jail. Is also pre-trial is also where people are sentenced for misdemeanors. Or if you have a felony and you're serving X amount of days in jail, which is less than a certain term, like we said. And so certain people are serving their sentence, certain people are sitting there pre-trial waiting for their sentence. And so if you're sitting there pre-trial waiting for your sentence and it's years go by, which happens. It happens for more serious cases because there's discovery, depositions. It takes time to work up a case, or there's turnover with attorneys or whatever the case is. And so what happens is that you're gaining credit during that time for every day that you're serving is going to go towards your sentence. And so let's say you serve, I don't know, sometimes crazy numbers like 3,000 days or something, I don't know. And so then you have to, when you take your sentence, you subtract your sentence from those days from your sentence. And that's what happens when you get a time served plea. It's like 600 days credit for 600 days,
Right.
So then you get released that day, but you didn't, technically that would be considered, a prison sentence, but you're getting time served. So you're getting released from the jail. So it's just, there are so many nuances that, that technically doesn't matter for purposes of sentencing generally, unless you're getting time served.
Right.
And that's why I was saying this is the only math that we really do, because we do have to count from the date that they went in. Sometimes clients go in, go out, they get arrested again, they pick up a new charge, and then you're like having to do for real math, and you're like, oh my gosh, like, I don't know, I need help, and I have to double check my work. I'll do it 2-3 times just to make sure, because every day counts.
Well, in the government side, they're the ones that have to come up with the score sheets, which we're going to talk about. That's all a computer software that does all that, thankfully, because it's a big grid of all the charges, and there's specific points that go to each charge. And if there's enhancements, there's more points or there's less points. And that is where criminal defense attorneys, we always joke, criminal attorneys in general always joke that we're not good at math, but that is where math is important in our profession.
So before I go into misdemeanors, you can take a plea knowing what plea you'll get from the state attorney's office, and it's an agreement. And like, if you're going into custody, you can even negotiate what day you're going to go into custody and like all those things. Great. So that's like the most seamless thing, right? Or way to kind of get sentenced. The other two ways, which make things a little bit more complicated and also come into play in discussion when we're talking about should we go to trial or not, because what happens is you could face way more time if you go to trial just because of certain enhancement designations that could apply to you that the prosecutor is choosing to not go forward on if you're willing to negotiate and take a plea with them. And so that's why even if you have a very good case, you still need to consider the plea offer given by the state, because at that point, it's not just, and this is really more for serious cases or felony cases, it's not just like, well, can they prove this or not? Because there are other things that, one, there's no guarantee, and two, there's other things that come into play, and that's how much time you are going to be facing, or how much time the judge or the state cannot go below this once you are found guilty. So all that to say, you could plead guilty to the judge and say, hey, judge, I plead guilty. Sentence me. And you have no idea what that is.
Well, yeah, that's true. But you could, I mean, that's why the more serious the cases get and the score sheet comes into play, that's where
You're
things
less likely
get
to do that.
dangerous and you're less likely to do that, because a prosecutor can say, okay, well, your guy on this charge faces 5 years, but because of their criminal history, they're actually starting at 10 years. The prosecutor can say, but if you're willing to take a plea, we're willing to give you less than those 10 years, and we're willing to waive that minimum. You can get that done in a negotiation sometimes, but that's not something that you can ask the judge to do, because if you say to the judge, I want you to give me the offer, and you already start at a certain point, the judge has to start at that certain point. So the judge says, oh, okay, you're pleading on something that's 5 years, but I actually have to start at 10 years because of your criminal history. You can't, unless there's a way for them to depart, which we'll talk about, you can't get around that. And that's the idea of taking a plea to the court becomes less likely the more serious your charges get. Yeah.
And so in that scenario, the reason why it would be, let's say someone's facing 5 years, that would be, so there are 3 degrees technically in under felony. Obviously, there's certain things that are considered punishable by life felonies, and that's not included in what I'm saying, but there's a 1st degree, 2nd degree, 3rd degree felony. And so in this scenario, he was saying you're facing 5 years. That would be a 3rd degree felony. You're facing 5 years. But let's say you have like a manslaughter on your history, which happens often. People serve like a 10-year prison sentence and they get out and they have a murder on their score sheet, which makes you score up the wall. It doesn't matter what type of charge you have. And then you pick up, let's say, a 3rd degree felony, which is like, it could be literally a felony theft.
A retail theft that's over a certain amount, let's say.
Or like your 3rd one.
Right.
Which is an enhanceable offense. So like there are things that could be very minor and they end up becoming felonies. And then your minimum starting point is 10 years. And so at this point, you're talking about significant prison time that you could shave off your sentence because of whatever history that you have on your record. And so that comes into play for the guidelines.
The more serious the crime that you either had or that you're accused of, the more points that are associated when we're talking about a score sheet, and the more time associated because of the statute and the whatever degree the charge falls under. And then there's also, like I keep saying, and then there's the potential of enhancements.
Yeah.
We'll get into that. But I mean, an enhancement is something that can be the way that a firearm is used in an offense, or what accessory you have on you. And when I say accessory, I am not talking about your handbag, but I'm talking about like lock picks. I'm talking about other burglary tools. I'm talking about wearing a mask during a robbery, or wearing a mask when you're committing certain acts in general. That's in itself an enhancement. There are a lot of different things that can make the situation even worse. And you made a really good point. That's why negotiating, you can't always say shoot down negotiating right away, because you may be in a really bad position because of your history, regardless of whatever the current case on the table is. And that creates leverage for prosecutors, because they can make an offer on your case, which may not be that great of a case. That's a tough offer, and tough in terms of how much time, and tough in terms of tough to turn it down. They can do that because your prior history puts you in a really bad position where there's a high score and you are going away for a minimum mandatory time. Then you look to negotiating and you look to the prosecutors to come down.
Yeah, they are the only people who can actually like waive certain things. Like even if there's certain charges, let's say, have like the one that comes to my mind is felon in possession, drug trafficking cases that have, and certain types of drugs have certain minimum mandatories. And these minimum mandatories, oftentimes, before I say this, minimum, like if you serve any sort of prison or jail sentence, you are eligible, if you're on good behavior, for gain time. You can do like extra things while you're in custody to shave some time off. And that's not something that's guaranteed by your plea, but that's really up to you once you go in there. But when it comes to these minimum mandatory sentences, none of that is a thing. You have to serve day for day, every single day. You sign for 3 years, you're taking 3 years. You're getting out after 3 years.
Yeah, the only thing you get is the credit that you served pre-trial, but you do not get credit for
good behavior,
or programs that you participate in. That I have a client that resolved his case. It was a case involving a firearm. The case resolved to 20 years, and it is day for day.
Yeah.
He got the credit for when he was waiting for the case to resolve, but that's a day-for-day sentence. And that's based on the severity of the crime. That's part of the statute, and that's where the crime fits.
Yeah, and that's like the starting point for judges. So there's the guidelines are personal to you, but minimum mandatory requirements are on the statute. They're required as a part of the enhancement or the charge that you are like that's associated with your case. So those are things that cannot be departed from by the judge. But when it comes to the score sheet that's personal to you, the charge that you are being charged with right now in your history, those are things the court can depart from. And so, and mind you, the law says that even if they find that there are grounds for departure, they can still exercise their discretion and say, we are not going to depart from the guidelines.
Right.
And so that is also still a risk associated with it. Obviously, if you go to trial and you lose, attorneys should always, like, I think, file a sentencing memorandum and request downward departure if it's like if they can. But if you are found guilty of a minimum mandatory, the judge literally has zero discretion, and that's the minimum.
Right.
So there are certain things that you have to talk about pre-trial that are like sentencing really dictates when it comes to things like this, because I don't think people really realize the severity of certain things. Like, this is a really like common scenario that I've seen. Burglary with the charge of battery is a punishable by life felony in Florida. And I've seen the scenario so many times where it's like boyfriend, ex-girlfriend, vice versa. They get into an argument, and one person ends up like getting into they're outside the house or they're inside the house, and someone ends up going and throwing shit. Like, it's really just a domestic issue, and it escalates, and it's like, oh, this person wasn't welcome here. He was coming over to get his stuff, and then he hit me, and then this person is facing life as a result of that. And now instead of talking about just a domestic battery where you're facing a year in the jail, you're talking about life, like the rest of your life. And obviously that doesn't mean people are going to get life, but it's not taken lightly at that point. You know?
No, it's much more serious. I've seen cases where somebody was in their car and gets into an argument with somebody outside of their car. The person outside of the car reaches into the car and either grabs their phone or hits them, and now they're calling it a bird bat, and it's a punishable by life offense, which is ridiculous given the circumstances.
Yeah, exactly.
But that's the way that it happens. That's totally true.
Yeah.
Yeah.
So, speaking on the degrees, because I didn't fully flesh this out. So, first degree misdemeanor, up to 1 year in the county. Second degree, 60 days. Up to 60 days. And there are fines. It's a $500 fine, I think, for second degree. And then
up to $500 for second degree, up to $1,000 for first degree.
Yeah. And then for felonies, a third degree felony in Florida is punishable by up to 5 years. Don't know the fines on this one. Second degree felony is 15 years maximum. And then first degree is 30 years. And then obviously there are charges, like we were saying right now, that are associated, that are like life.
Punishable by life offenses.
There's 10-20 life law, where it's like if you have a firearm while you're committing a specific felony, or if there's a discharge or causes, injury, there's enhancements, and those are the minimum mandatory. So obviously we don't expect all of you to know this, but there are things that people should know about, I think, the court system and criminal law that is like, people should know this. You know?
And I think it's important because a lot of people do wonder, why do certain judges sentence the way that they do, and why do certain people get the amount of time that they get versus others? And a lot of it comes down to, especially the more serious you get, their criminal history and what the judges are allowed to do and where they're allowed to start. And a lot of it comes down to the negotiations between the defense attorney and the state attorney's office, because the best deal oftentimes that's going to be made is going to be made that way. And that's going to be way better than what the client would get after a sentencing, whether it's the judge deciding after a trial or pleading up to the judge and the judge deciding. You have a way better shot of getting something better from the prosecutor.
Yeah.
Misdemeanor cases, sometimes you have a good shot of getting a better deal from the judge.
Yeah.
But we're talking charges that are not serious, when we know jail is really not a major factor. Or we're looking at a difference of, 30 days in jail between what the state's offering and what a judge may throw at you. those are different discussions. We're not talking about 30 years in terms of a difference.
When you're rolling the dice like that, it makes such a difference. Like, am I really going to go in front of this judge? And so, like, speaking on misdemeanors, though, there is something that I learned as a public defender, that you could do pre-plea inquiries in court, and not every judge does it.
So you can and you can't.
Yeah.
That's funny, because I was always taught you cannot.
Okay.
Which is fun, because a pre-plea inquiry is basically saying to the judge, if I plead guilty or if I'm found guilty, what is the sentence going to be?
What would you give me?
And the problem is that, and this happened, that if judges give an answer to that, which they can give the answer to that, there's an argument to be made by a public defender after trial. If the judge doesn't stick with that offer and the judge gives something worse, the public defender can say, oh, you need to recuse yourself. You're not fair. There was no way that you should have done that. You can't go above. You already gave a number. It has happened where but that's not fair. That's why you have heard judges say, oh, I don't do pre-plea.
Yeah, some judges don't. Well, I would think that if they go to trial and they decline that offer, it shouldn't be on the table anymore. Like, that shouldn't be a thing.
Correct. But because the judge
said it,
there's an argument to be made that the only reason the judge is going above what that number was is because they went to trial.
Or because they learned more about the facts.
That's the actual reason. And there is a genuine, legitimate reason to do that and to sentence above whatever that was going to be.
For sure.
But then you also have people that have made the argument, and that is why it is, they
ruined it for us.
It's silly, but that's it. But that's why you see certain judges are like, oh, no, I will not take a pre-plea.
I think there's a way to word it, though. Some judges who I know don't normally like to do it, though, it's basically like, we're going to plead guilty right now if you'll give us because we're disagreeing on X, Y, and Z.
There are certain things, there are certain ways that judges will, like, there was a case where I had a client that pled guilty to a domestic battery and was on a plea impasse for a domestic battery. And the same day that he pled, he got a new case, a driving under suspension case. But his license was valid. He was able to get his license valid, and it was fine. The judge still issued a warrant. He came to court. I brought him in, and I said to the judge, like, this happened this day. His license was valid. It was just a technicality from the DMV. The prosecutor said 120 days in jail, and the
that was
judge,
the downside?
No, that's just what was their offer now on to resolve the case. That they were saying the plea impasse was done. The judge in the case heard it, and I wasn't going to plea to this judge because I was under the impression that this judge would go way higher. The judge heard the conversation I had with the prosecutor, said out loud, it was probation, not a plea impasse. Said, Mr. Dinitz, if your client is willing to go back on probation right now, we can resolve the case. And we did it.
That's nice.
Yeah.
Yeah. Sometimes judges they help resolve the case.
Yeah. It was not a plea impasse, for the record. It was probation, but he hadn't taken it yet. He had it on the table. No, he took it. He was on probation, but the day that he went on to probation, he picked up this new charge.
Which would be considered a VOP.
Right. And it was, and the judge issued a warrant. But when she heard what had happened, she was like, oh, okay, I'll let him go back on probation. But one of her, like, the ASAs that in that courtroom that are like afraid of that judge, they were like, 120 days. And the judge squashed it, which was the only time that's ever happened.
Surprising.
And
Cool.
It was beneficial, and I will forever be grateful for that.
Yeah.
But, yeah.
Yeah. Oftentimes they don't like to do it, but I still shoot my shot. I'm like, hey, we'll do a pre-plea.
If the judge is willing to do a pre-plea inquiry and you're not going to go bananas after, then go for it.
But sentencing oftentimes in misdemeanors, especially even after trial, happens like right after. So sentencing is usually its own hearing, and you have basically your witnesses that you want to call to prove whatever you need to prove. If you want to prove grounds for downward departure, mitigation, even that are not technically like codified in the law. And you want to be like, this person's a good member of society. Don't lock them up.
Or the opposite. You have people and families coming to sentencing that are
like victims,
and they are going to say whatever they want to say to the defendant. And that's, you have those people, those victim impact statements, oftentimes those carry good weight, and a judge will hear that and think to themselves, wow, like, look how these people are affected. Sometimes, though, you have sentencing that is, because everybody already knows what the sentence is going to be, like what I'm thinking of is the Idaho murders, the college students. That sentencing was all for the victims to make statements because everybody had already agreed, and it was agreed that it was a life in prison. There was not going to be, so there was no need to really do it that way. And sometimes in cases where the judges don't do a sentencing or don't do a separate sentencing hearing, they're doing sentencing right away because there is no other sentence that's going to be happening. So if it's a mandatory by life offense and they're going to be going away for life, they're convicted of murder and you're going away for life, they don't need to do a delay and do a sentencing hearing. They can, but they can say, I'm sentencing you to be sentenced to life. Right. That's it. That's the end of it. So
it's really the in-betweens.
Yeah. It's the in-betweens because in DUI cases, for example, the person has to be sentenced right then and there because they have to be put on probation right after being convicted.
Right.
And obviously everything we're talking about in this episode is in Florida. So that's required. But in certain other cases where there's a jury trial, oftentimes the judge will say, we're going to set out sentencing for a few months. And there's different reasons for that. One is we've all just gone through the stress of a trial and we're all exhausted and there's no reason to do this right now. The person's I'm holding them in custody. There's no reason to do it right now. The other is that it's not statutorily required under the charge in that case, so they can push off sentencing. Another reason is that judges sometimes require pre-sentencing investigations. So a full report is done up on the person that is being sentenced, and that can aid the judge in their decision-making for what type of sentence they give. There are the opportunity for the defense attorneys to write sentencing memorandums. There's the opportunity for the state to write a sentencing memorandum. And these are all things that the judge can then take time and consider before coming up with what the sentence is going to be.
Are high-interest credit cards or personal loans weighing you down? Unlock gives homeowners a smarter option. With a home equity agreement, you can tap into your home's equity for cash today. There are no monthly payments. Here's how it works. Unlock provides funds upfront and in exchange, shares in a portion of your home's future value. That means you keep control with the flexibility to use your equity your way. Pay off bills, invest in home improvements, or set aside savings for peace of mind. For thousands of homeowners, Unlock has been the key to moving forward without the pressure of another payment. Put your equity to work for you. Visit unlock.com to learn more about a home equity agreement. That's unlock.com to learn more.
Terms and conditions apply. Not all homeowners will qualify. Not available in all states. Actor Portrayal. Home equity agreements are offered by Unlock Home Equity Solutions, Inc. In certain states, NMLS number 2657081. Visit www.consumeraccess.org for more info.
And that's often, you see that in a lot of cases. That's what happens.
That's exactly what happens. And then obviously at the hearing, the judge by then would have reviewed everything, and then you just present your witnesses and the state presents their witnesses. So state usually goes first and then defense, and each side requests something. Even if you were saying I was innocent at trial and you have sentencing, that doesn't mean that you can't ask for a sentence. You should ask for a sentence from the defense side because you don't want to just you want to guide the court, I think, in a way that's like, hey, we are requesting this and because of X, Y, and Z. And I think sometimes it's reasonable. And if it's a reasonable request, the court will use it as a guide and be like, you know what, I think maybe that plus some jail or that plus some in-house arrest or whatever, gets the job done, or depending on what the case is. But it's oftentimes, I think, I don't want to say the most important, but it's sentencing is so important. It's just, especially the amount of energy and work that goes into it, it's just as much work as something that would go into trial, I think.
And I think it's also the least pleasant process that we deal with for a lot of reasons. And I think that's for both sides. If you're the prosecutor and you just want a big case, you have that anticipation for sentencing that you're excited for because of all the work that you put into it. But if you're dealing with a case where you have victims and everything else, that sentencing is going to be really, really hard. I had a DUI manslaughter that we wound up having a plea, and not a plea to the court. It was a special plea that the judge set out separate. So it was its own hearing, and the family came in, and I was a defense attorney on this case, and the family of the deceased came in and gave statements. And it is really hard. And even if you're on that side and you're like, oh, judge, I'm giving the judge all the reasons to throw the book at the defendant in the case, you sitting there and listening to those statements is really rough.
Yeah.
Regardless of how many times you've reviewed the evidence and what you've seen in the videos and what you know about the case and what you know about the deceased, it doesn't matter.
There's
When
a
you're
human
sitting
element to it.
it is really, really difficult.
Yeah.
And I think sentencing in general is tough. It's not enjoyable for anybody. And the judge has a tough decision to make because they want to do what's best for the community and what's best under the law and it
affects
take into account
life.
what this other person's dealing with.
Yeah.
You never know, and it's rough.
Yeah, I think that I always thought about I not that my aspiration is to be a judge, but I think about a judge's job and the life of a judge because I just think about it. And so I think that I really have come to the conclusion that sentencing is the hardest part of their job. I think they have to make so many decisions in the day, and that's on legal issues, factual issues. Yes, that can't come in. No, that can't come in. Yes, you have to turn over discovery or all these things. I think the hardest thing they have to say is you are being sentenced to X, Y, and Z, whether they want to do it or not, because that is affecting so many different moving parts. And so obviously there's very rarely ever, state is always on this side and defense always on this side. So they have to find something that's going to be reasonable for both or reasonable for the circumstances, maybe not even for both, maybe not for one side or the other. They just think that this is what's fair considering all the circumstances and everything that's been heard. And I don't think that they take it lightly.
No, it's not easy. I don't think handing out a life sentence is something that a judge takes lightly, even if it's a case that's gruesome and they still have to learn all about the case and the impact that it had on other people's lives. And just because at the end of the day, they get to be the last ones to close the book on it to an extent, it doesn't make the decision easier.
So speaking on score sheets, because we did talk about your primary offenses on there, meaning the most serious charge is the one that carries the most points. And then there's supplemental charges because sometimes people are charged with, I don't know, a bunch of charges. And that could be you have a gun charge, you have drug charges, whatever. And whatever carries the most points goes first. And then there's the added on charges below that. Then there's your history. There is a portion on there if you were on probation, you violated your probation. If you injured somebody, victim injury, you get extra points for that.
Right.
And it's not good points. More points you get, the higher likely, the higher the chance that you will be getting a minimum sentence of prison.
Right.
That's
and specifically, once the points get added up, you have to get to a certain point to actually score prison.
Yeah, exactly.
So once you get to that threshold of points, which is 44, once you're at that threshold, you now are scoring 1 year in prison.
Yeah.
And that's where the judge would have to start. And there's a box on the score sheet that basically says, whatever the final score is with its final calculations minus this plus this XYZ, that number, if it's 44 or higher, that is the minimum mandatory. So that means, yes, that if the case resolves and the judge is put in a position where they are going to be doing some sort of sentencing, it is starting at that number.
Yeah.
And it's in months, those points.
Yeah.
That number is in months. The ultimate points number, that shoots out. So if it's over 44, we're talking about the number of months.
Yeah. And so you said minimum mandatory, but I just want to clarify because we call the minimum mandatory on a score sheet the lowest permissible sentence in months because that is, like I said, not a minimum mandatory legally. Technically, the term minimum mandatory is a day-for-day sentence. You're not going to get out before that, and you can't depart from that. Whereas the lowest permissible sentence, if you have grounds for downward departure, which could be the need to pay for restitution. Let's say if somebody was injured and they need to make payments back to the victim. And the argument from the defense side is, okay, the victim needs to be compensated, then our client should be out of custody and on probation making money so they can pay the victim back. Because if they're in custody, this victim's never going to get their money back. They're never going to get their bills paid again. So that's also kind of a reason to incentivize the court, the victim, or the state to be on board with downward departure. If you commit a crime under a certain age, you could be considered a youthful offender. There are so many different ways to depart from the guidelines. And that is also a part of the conversation, again, when talking about negotiating with the state or whether your case is a strong case, because sometimes the grounds for downward departure is a reason to go to trial. If you're YO, you know that you are a you would get a youthful offender status, even though the judge can technically still say, no, I'm not going to give you YO. That's an incentive to go to trial if you feel like you have a triable case,
Because
but
it
then
gets you out of that required score. It
Right.
takes you out of that. That's why.
Exactly. Also, another ground for downward departure is a plea bargain. So that's literally codified in the law. Like if you plea with the state can basically do what they want.
Yeah, that's true. And I had one case that a client scored 44 years, and that was his score. So if we would have asked the judge had to start at that. And ultimately the prosecutor was willing to come down from that dramatically and give him a 20-year sentence. But, still that's only something that the prosecutor has the discretion to do. The judge couldn't have done that.
Exactly.
And the judge almost didn't give the 20 years because of how high the score was. The judge almost rejected the plea, which a judge has the ability to do. And I don't know if we've discussed that.
No, we should talk about that.
Judges can reject pleas, and they do. It happens frequently.
Unfortunately.
Where a judge will think that a plea is
too lenient,
and they will reject it.
They never think it's too tough, though.
I'm trying to think. I really do think I have an example in my head where there was a county court judge that thought something was too tough.
Really?
Yeah, but it was like it was a long time ago, and it was like something kind of ridiculous was going on. I don't remember. It wasn't my case, but I almost remember the judge rejecting the plea, and like that it was definitely because it was too much. There was too much going on, and I think the judge kind of just made it seem like it was too complicated of a plea, and that was why he was rejecting it. But I think the judge was making sure that the defendant wasn't going to be set up to fail.
Yeah,
and I think that's what the judge was seeing when I think it was a probation term that was not that long of a probation term, but had requirements that probably couldn't be completed in that amount of time. Like knowingly setting a person up to fail, like the judge didn't want to do that. Yeah.
Well, that's one of how many?
Thousands and thousands and thousands and thousands. That doesn't happen ever.
Yeah, exactly. Like they just, I don't know. I've never seen it, but it
could happen.
Yeah. No. I've definitely seen it where they reject it because it's too lenient. That's definitely a thing.
Sure. That happens all the time.
Yeah.
And one thing that we've been talking about is enhancements and what can drive a score up or multiply a score. The enhancements are power-ups, for lack of a better term, because what they do is take a standard situation or a standard scenario where someone is accused of, let's say, burglary, and they're facing X amount. Well, if you start adding enhancements like they had a mask or they had a firearm, now whatever they were facing is dramatically worse. And what I think the point of these enhancements is to try to deter people from doing these crimes in general, but the added things. I mean, if you're going to rob a bank and you put a mask on, your concerns in terms of sentencing is way higher. Not that I think you were really concerned to begin with if you were already robbing the bank, but that is the point. Like there are different things that happen that can be enhancements. So like I said, wearing a mask during a robbery, or you had mentioned firearm enhancements, 10-20 life, right?
There's also PRR.
Right.
Where that's like prison release reoffender. And that's when you're released from prison after like a certain amount of time, you commit a specific, it's designated crimes. It's not any crime, specific crimes. And if you are charged with these crimes, you are having, like we say like PR 10, like that's like the minimum that you'll see. Yeah. So
there are enhancements. Everything goes up if you are, but that, I mean, again, that in an objective sense, that makes sense. If you just got out of prison and you just picked up a new really serious offense, the punishments should be higher. I mean, that just makes sense.
Yeah. But it takes out I don't want to say all the discretion, because again, the state uses it as leverage. So it does, but they do take into consideration and they do use it to negotiate, but it takes out the discretion from the judge, because at that point, the court can't do anything that you're PR 10.
Right.
Well, the state has to prove it actually at sentencing. So that's the other thing. When you go to sentencing and there's habitual felony offender, habitual violent felony offender, there's prison releasee reoffender, like violent career criminal. Like there are all these different things. 1020 life, they have to prove 1020 life. I think they prove with the facts, but at sentencing, they have to prove that you are designated under these. So they would have to show that you were previously convicted and previously went to prison and you were released on this date.
Which is very easy to do.
So easy. It's like one document that's like taken in.
Mm-hmm.
But yeah, that's something that obviously like once it's proven, the court can't do anything about it.
Right. I mean, but they're there for the enhancements are there for a reason. And they just make matters a lot worse because they, again, from a defense side are less that we have to work with. And from the prosecutor side, it's also less to work with because your hands are tied on to some extent based on that being the statute, that being what governs how much time you can, that person potentially could face at least.
Yeah.
So,
I think that's the shitty part, I think, in general for the defense. But that's the other thing is like, that's what makes mitigation so important because that's when we come in and we present to either the state or the judge why, if the judge has a discretion to depart, why they should depart or why they shouldn't follow the guidelines, why they should give our client probation, why this person shouldn't go into custody, whatever the case is. And that could literally be education, mental health, substance abuse, your upbringing, and like so many things that people don't think is important are so important. And those are things that we talk about. And it's not like, just as the state or the government wants to paint this picture that you are a criminal, we want to paint otherwise. Like we want to show that there's more to this person aside from their criminal history or the charges or the allegations that are being said against this person. They deserve a second chance, and let me tell you why. Or maybe this is not their second time. They have a crazy rap sheet. Why are they in this situation? And so oftentimes we're not excusing behavior. At that point, we're explaining behavior because we have to show to the court like why this person doesn't know any better and hasn't been provided, resources to be better and why this time it's different. You have to show that because then otherwise, why are you asking for grace? Why are you asking for mercy in this situation?
Yeah.
And so
I think the downward departure is like the one time that the law says to the criminal defendant, okay, maybe you deserve a break. And that's the only time that there is you can look and see a codified system where somebody can be given a break in the system.
Yeah.
And this is really the only area where that exists. Otherwise, you're dealing with the mercy and discretion of the prosecutor or the mercy and discretion of the judge if they have it.
Yeah.
Other than that, downward departure is it's a unicorn.
Yeah. And then obviously when the judge can find grounds and say, I see there's mental health issues here and I see you've struggled, like they will say that, but I don't find that you deserve downward departure and you will be getting the minimum sentence or you'll be getting more than the minimum sentence. And then it's like, yikes.
Right.
There is also, that's a point to make because I find that a lot of times when I talk to my clients, they don't know what's important when they provide me information. I'm like, literally give me everything about you. Sometimes I'll even have my clients write me a bio just so I can get to know them a little bit better and have like something about them before sentencing, just so I can know about them before I can, approach the prosecutor and talk to them about negotiating because those are things that still come into play when you're negotiating. It's important. Going to rehab, if it's a DUI manslaughter, and if you're lucky enough to be waiting out of custody pretrial, go into rehab. Show that you are redeemable.
It does not need to get to the DUI manslaughter level for me to tell a client get into a rehab program. Like a second DUI inside of 5 years, they need to be doing, as far as I'm concerned, getting into some inpatient treatment because one, they need it, and two, there is really nothing better to show the court than they're taking it seriously and they're getting treatment. Because everything else beyond that is just asking for mercy.
Yeah, exactly.
It's not, they have to do something to show that. And one of the things you were talking about before was and I guess I had mentioned it, but like the mandatory minimum sentence oftentimes comes from whatever the charge is as well. Whatever the offense is, and this could be misdemeanors or felonies,
Right.
there could be a mandatory minimum sentence. So, for example, in misdemeanors and something that we deal with all the time, DUIs. So a second DUI inside of 5 years has a minimum mandatory of 10 days jail on it. That's where a prosecutor generally starts with a second inside 5 DUI. And I'll tell you, in other counties, they almost treat it like it's the minimum mandatory is 60 days or higher on certain cases like that. One of the other, I was just going to get there. The other thing is driving under suspension and driving without a valid license. Both of these two charges now have minimum mandatory sentences if you have a certain number of priors of them. And they don't even need to necessarily be priors of the exact charge. So for driving under suspension, if you have a mixture of prior DUIs and a mixture of prior driving under suspensions or leaving the scene of an accident conviction, you have those, or a drug conviction. If you have any combination of those and you have 3, you get a 10-day minimum jail sentence for driving under suspension. There are so many people that their licenses get in bad shape, either on their own or through the court process, and they're not able to pay off fines or they don't get everything squared away with the DMV. And then they start picking up those charges and now they're facing jail time. It happens all the time to regular people that just have issues with their license.
Non-criminals.
And it is right. Yeah. And it is a minimum mandatory that's really become serious between that and the right. The no valid driver's license minimum mandatory, I think, is more designed to catch illegal immigrants if you want to get, that's what I think they 100%. Did that. Because the majority of people that get the no valid driver's license arrests and jail are people that never ever had a license to begin with.
Right.
The driving under suspension people had one at some point and got
suspended.
Correct for whatever reason. Yeah. But you start adding those up and the judges aren't looking to downward depart at all from those. The judges are looking to put everybody in for
they do not
for
care.
the 10 days on those cases. And on the DUIs, it's worse. And the more DUIs you rack up, the better chance you have at mandatory minimum sentences.
Yeah, 100%. No, once you become, I think it's your 4th DUI becomes a felony. Yep. Mandatory felony conviction. You could have literally just DUIs on your record. I had a client like this. He would literally had never been in trouble aside from DUI in the past. He was being charged with a felony DUI and he was about to become a convicted felon, which literally affects your life in so many different ways that he was not prepared to do. On top of that, there was a minimum jail sentence required. And it was just like DUIs, I swear. They're going to be the death of me. They're so stressful because there's truly nothing anybody can do about it unless you are willing to put in the work and show that your actions speak louder than your words and get some sort of treatment to show that you are redeemable in order to, and that's for the state and the judge. The state wants to see that because otherwise they are enforcing these 10-day minimum sentences, 30-day, it goes up to 30 days, and then these felony convictions required associated with it. It just fucks up your life.
The more DUIs you get, also, there's onus is completely on you that you need to get your shit together and figure it out because it is difficult to get a DUI nowadays. You have to go out of your way to
just Uber.
Exactly. There are so many different options for not getting a DUI nowadays.
It's much cheaper than DUI probation. Trust me.
Yeah, an Uber or a bus or anything.
You spend $10K.
It's very different. Fabi was on here. Fabi said an average DUI is $10K before you get lawyers involved.
Yeah.
So
the things you have to pay for, and required to do prior to even getting your license to reinstate it is whole nother conversation. You just pay up the ass in fines, fees.
And then the collateral consequence of insurance. Then you need special FR44 insurance that costs anywhere up to, some people pay $7,000 a year and you have to pay upfront. 3 years, I think you have to pay upfront, something like that. It's out of control. This is why people are driving around with
because they can't afford
licenses because they can't afford to get it fixed after their DUI conviction.
Literally.
Yeah. That
oh my
makes
gosh.
it tough. But that's a different topic for a different.
But I do know some good insurance agents if y'all need them.
You know some good insurance agents?
One of my best friends is an insurance agent. So
there you go.
Send them anytime my clients are I need an FR44 insurance. I'm I could know the guy for you. Just forward over his contact.
Yeah. Well, we also know good lawyers for the DUIs. So before it gets to that point.
Yeah. Clearly.
Reach out to us
Obviously.
first.
Yeah.
Then we'll deal. We'll help you.
We'll help you with
We'll help
everything.
refer you to insurance after the fact. But
Yes.
Yeah, right. Exactly.
Okay. Well,
But anyways, just sentencing in general. It's the sentencing in Florida comes down to math and some human element in terms of, departures and negotiations, discretion on the part of prosecutors, sometimes discretion on the part of judges, and then morality. Everybody involved taking a position of what they think is best for everybody involved.
yeah. And I think there are just a few points that I just want to highlight.
Sure.
I just don't want it to make it seem like we're all for pleas. I just think that pleas allow our clients to feel in control, a sense of control, versus pleading up to the judge or going to trial, because you really know the outcome. You are so aware and involved in the agreement that it's something that is really in your hands at that point. And oftentimes, if you're willing to talk about what you want, you can ask the government what it is that they want to see from you in order to get that on the table. Sometimes I will ask the state, my client's doing X, Y, and Z. What is it that you need to see from my client to get this? Because it's at that point, I've asked many times and they've said no. So it's what can I do or what can my client do in order to gain this advantage for him? And if sometimes they give me an answer and they're more anger management or more get him in therapy and show me the evaluation. We'll talk again, and I'm okay, go sign up. The onus is on you, So it's if you want control, you got to put in that type of work. Otherwise, if you want to go to trial, just know that there's a risk associated, whether you have a designation or minimum mandatories. Again, you can't get gain time, can't get out early for good behavior, none of that if it's a charge that has a minimum mandatory, which is obviously something they'll be aware of before they go to trial. But I think that at the end of the day is a big part of the conversation of sentencing. And it's not just sentencing is down the line, we don't have to worry about it. Sometimes, if it's a battery case or whatever, and then you're just going to trial on a misdemeanor. But once you're in felony world, it's a whole different ballgame. Or DUI, like you said, DUI, DUS. There's just certain arenas in criminal law that once you get in, the first thing we're talking about is sentencing. Not because you're going to prison forever, but because that's a part of your decision making. You need to know this.
Right.
So that's my little 2 cents.
I agree. I like it.
Well,
I think that's all we got for today.
cool. So if you like listening to us, make sure you check out the show notes and make sure you subscribe to our newsletter to get our weekly gems in your inbox. And make sure you comment, and subscribe to all of our videos and all the things on our platforms that come back with a warrant.pod, and leave us a 5-star review. And if you didn't like listening to us,
Come back with a warrant.
Are you ready to finally make that dream a reality? Maybe it's updating your kitchen, paying down high-interest credit cards, or covering tuition. Your home is more than where you live. It's also your most powerful asset. At Unlock, we make it simple to turn equity into options. With a home equity agreement, you can access cash today without taking on monthly payments. Imagine the freedom to invest in your home, reduce financial stress, or finally start that big project you've been putting off. It's your home. It's your future. Unlock it today. Visit unlock.com to learn more about a home equity agreement. That's unlock.com to learn more.
Terms and conditions apply. Not all homeowners will qualify. Not available in all states. Actor Portrayal. Home equity agreements are offered by Unlock Home Equity Solutions, Inc. In certain states, NMLS number 2657081. Visit www.consumeraccess.org for more info.